Hello, and welcome to Your Estate Matters with your hosts, my colleague Greg Brenand and myself, Nicole Garten of Heritage Trust.
Your Estate Matters is a podcast dedicated to everything estates, including building and preserving your legacy.
If it's estate related, we'll be talking about it. We're having the conversations today that will help Canadians protect their families, their assets, and their legacies tomorrow. So, Holly, tell us about yourself and your journey to your current role as a partner with MMP.
Great. Thanks so much, Nicole. I'm really excited to be here. This is my first podcast, so looking forward to it. Insolvency is a very unique profession. I think everybody that I've talked to that is in insolvency kind of fell into it one way or another, which is exactly what happened to me. I started out my career when I was in university. I started out my career as a controller for my uncle's company, and then decided I wanted to be a real accountant. So I started at a professional services firm in public practice. They start us in the audit group, which is audit. It's necessary, but it was the 2008-2009 financial crisis. So lots of businesses were needing restructuring help. So they pushed me into the insolvency team. Right away, I was out at a company by myself, basically running a distressed company. And it was exciting to me. We had to figure out whether or not to continue it, the business, whether or not you needed to continue with certain employees or work in process, and really liked the insolvency aspect of it. So continuing on with that. And then I lived in the UK for about 6 years doing large-scale cross-border insolvencies, which was interesting. Got to spend some time in Bermuda and Cayman, and then came back to Vancouver in 2017. And I worked as a partner at a Big Four firm for a number of years, and then started with MNP last November.
So what happens when somebody passes away with more debts than assets? Could you walk us through that process of settling an insolvent estate?
Sure. So in the will, there will be an executor. If there's no executor, then there will be an administrator that's appointed in the court. If it's an insolvent estate, usually that administrator, it could be a family or a friend, or it could be a licensed insolvency trustee, which is what I am, what MNP is. So when the administrator is appointed, they'll go out, identify all of the assets, assign values to them, run sales processes, bring all of the money and the proceeds from those sales into the estate, and then they will call for creditor claims. So we notify all of the creditors that there is the deceased, and to let us know the administrator know if there's any amounts due to them. And then we would pay out the creditors based on a priority under either provincial or federal law, depending upon if it's bankrupt or not. And then the administrator would pay the amounts out, do the tax returns, and apply for discharge.
So tell us exactly how do creditors get paid, and how do you decide what the priority is of who gets paid versus other people?
Yeah, so it's based on a legal priority. If it's an administrator working under the Wills and Estates Succession Act, it is one set of priorities. That's a provincial act, so the BC Provincial Act. And then if the estate is bankrupt, then it's actually the priorities come under the Bankruptcy and Insolvency Act, which is a federal statute. Those two priorities or hierarchies of payment, they're mirrored. They're pretty much the same under both acts. So normally, and just to summarize it, it's funeral costs, reasonable funeral costs, probate fees, administration fees, legal costs are paid out first. And then there's secured creditors. So if there's bank loans, et cetera, the secured creditors will either seize their assets, realize upon them themselves, or a receiver will, or the administrator can realize upon the assets, pay the secured creditors. And then the preferred creditors, so once they're paid in full, the preferred creditors are next, and those are people like source deductions outstanding for CRA or GST outstanding. If there's businesses involved, sometimes there's employee amounts and some other preferred amounts. And then you've got your unsecured creditors. So they're getting, if it's an insolvent estate, there's not enough assets to go around. So they're getting cents on the dollar effectively, being paid pro rata percentage of their claim based on the other creditors.
So how is it governed by provincial or federal legislation?
So if it is the administrator or the executor that is administering those assets and paying them out, then it would be under the provincial WESA Act. And then if the estate had filed for bankruptcy or the executor had signed it into bankruptcy, then a trustee would be appointed, and the trustee administers it under the Bankruptcy and Insolvency Act, which is the federal statute.
So how does an executor know if they should be in bankruptcy or not?
Yeah, so it really, first of all, in order to sign it into bankruptcy, it does need to be insolvent. So if the estate's insolvent, the executor does have some liability. They need to make sure that they're realizing upon the assets for their maximum value, which when it's insolvent, there's already not very many assets. So you need to make sure you're getting all the money you can for them. So selling them improvidently could get them in trouble. Also, if you don't follow that priority when you're paying out the debts, that could also get them in trouble. So if an executor doesn't want the stress, maybe they're a family member and it's a lot, or there's a lot of contentious, litigious creditors that are knocking down their door, being really difficult, it might be better to assign it into bankruptcy and have a licensed insolvency trustee that kind of deals with these types of creditors and negotiations every day come in and take possession of the assets of the estate, realize upon them, and distribute them. And that actually moves the liability from the executor for those activities onto the trustee. And then there's a very limited role really for the executor at that stage.
So what is insolvency exactly?
Insolvency is, all it means is that your assets are less than your liabilities. So it's just a factual thing rather than being a legal process or anything like that. That's what insolvency is. Or you're not paying your debt. Under the Bankruptcy and Insolvency Act, you can simply not be paying your debts as they come due. And that can mean you're insolvent. Maybe you do have enough assets to pay them, but you're just not paying your creditors. The creditors can actually apply for your bankruptcy. So that's different than bankruptcy, which is a legal process where the estate or the executor will assign the estate into a bankruptcy, and then the trustee gets appointed there. It's all court supervised. And then the trustee, or the LIT, as we call them, a licensed insolvency trustee, they are a court appointment. So they are officers of the court and have to act independently.
So this is a very common question. Are family members ever responsible for the debts of a deceased person? And what should people know to protect themselves?
No, I don't think generally family members are responsible for debts of a deceased person. I think if you're a co-signer of debt, or if you hold debt jointly with the deceased, then there is the possibility in both of those cases that you will be liable, especially in an insolvent estate, because there's not enough money to pay back creditors. So when the insolvent estate, which is only going to be responsible for their portion of that joint debt or the guaranteed debt or co-signed debt, if there's no money to pay that portion back, the entire rest of the portion owed is owed by the co-signer. So that's where you could get some liability for debts of the deceased. And then the other place where liability could happen is if the family member is actually the executor. And then we talked about some of the risks that an executor might face if they don't administer properly.
So let's talk about that. Someone passes away and the executor looks at it and it looks like either it's on the edge or clearly the debts exceed the assets. How does the executor decide what to do next?
So I think with the executor, I guess it depends upon their appetite for risk and how sophisticated they are with actually dealing with these situations. Maybe they've dealt with it before, an insolvency situation, and they're comfortable doing that. I think the first step is they probably should call someone like me just a chat, so that they can decide whether or not they're comfortable in that role, or do they need to get some court supervision of the process? Do they need to appoint an administrator, which could be an insolvency professional, or it could be another family member to administer for them, or do they need to assign it into bankruptcy so it can be under the protection of the Bankruptcy and Insolvency Act? But it really depends upon how comfortably they feel and how litigious and contentious the situation is with the other creditors.
So say somebody calls you to have a chat and they say, like, what are the risks? I think you referenced that before, is that if they don't sell assets for full market value, or maybe they make a mistake with the order, that could they be personally liable for debts?
Yeah, so if they're acting with due diligence and care and they are not doing anything that's negligent, they may not face consequence, but they have to be doing their best efforts to maximize on those assets, right? So instead of just selling an asset to your friend, you would need to, if it was a house, you need to get appraisal and make sure you were selling it for the maximum value. Or if it was a corporation or a company that was owned, you would have to get that valued and run a sales process potentially. So there's certain ways you can get the most value out of the assets that you're selling. So simply inquiring to a professional, like, what can I do here to make sure that I'm maximizing? Because they might not know if they're not in the business of buying and selling assets.
Right. And that leads to, what's the standard that would be measured of a person doing it versus a company or a trustee bankruptcy doing it. So if they've made perhaps an error,
yeah,
they're not going to be held to its highest standard, probably.
Oh, goodness, no. Yes. No, they certainly wouldn't be. I think as long as you're acting prudently, and you're acting with due diligence in good faith, I think that you would be fine as an executor. We are certainly held to a very high standard. A lot of what we do in the Bankruptcy and Insolvency Act as a trustee is also approved by the court. So there's all sorts of precedent in the courts as to what constitutes appropriate sales processes for certain assets. So we're definitely held to a higher standard, which makes sense because this is our profession.
So, and in this type of process, is there any way to shield certain assets from being claimed by creditors after death, such as trusts or beneficiary designations?
Yeah. So there's a few things. So if you have, so basically designating beneficiaries. So if you have RIFs or RRSPs or life insurance policies, TFSAs, appointing a beneficiary to those is important. So if we were to come in as an insolvency trustee or an administrator, then the first thing we check is this an asset of the estate? Do we need to take it? If it's a beneficiary and it's a properly set up trust, then that is just not an asset of the estate. So we wouldn't collect it in for the benefit of the creditors. And say it was life insurance, that would be paid directly to the beneficiary. There's also trusts that you can set up, the intravenous trust or the living trusts, where while the deceased person is still alive, you can transfer assets to somebody else, and then those are seen as in a trust and held outside of the bankruptcy system or outside of the estate. And the only thing that you may get pushback, and you might get for more pushback from a trustee, is if that trust was put up with the intention to defraud or defeat particular creditors, so it was set up kind of right before the person dies in order to defeat a creditor, then it could get unwound. But for the most part, that's a good way to protect assets.
Well, there was a recent case where a widow was in litigation with the CRA for many years, and that she was the beneficiary of a RSP, but the deceased husband passed away with a large debt to the CRA, and the CRA took the position that it should be entitled to the RSP. And I think she lost in court, but won on appeal. So that was interesting. That was just a case that came out a few months ago.
Yeah, CRA has actually been very unusually present in lots of these situations where they weren't before. So especially in insolvency situations, we're seeing them show up in court, try to realize on guarantees that they weren't before, try to go after certain debts that they perceive to be, their trusts, not someone else's. So I'm not surprised to hear that. Yeah.
So what about interfamily loans? So there's, a parent has loaned funds to a child or between siblings. Would those fit the unsecured creditors, or how does that factor in when you've got more debts than assets?
Yeah. So if a parent who is deceased has lent to a child, yep. So if a parent's deceased has lent to a child and there's no agreements in place for it, and it's a minor child, it would probably be determined to be a gift, and therefore it wouldn't be a state asset. If the parent has lent to an adult child, it would be assumed to be property of the estate unless there was some documentation that said it was a gift or that it was forgiven or the will had said that. So unless those are there, then I would assume an administrator or a trustee would probably pursue the asset and try to collect it into the estate. So it's very important to have all of those loans in writing, although I know they never are, or they very rarely are.
Right. So what happens if somebody dies owing money to a family business? Can the business claim against the estate?
Yep. So the business is a creditor like anybody else. If the estate owes the business money, then during the claims process, in either under WESA or under the Bankruptcy and Insolvency Act, they would call for claims. The business would put the claim in. It's very important that there's documents for that, because the trustee or the administrator is not going to accept just a note that says they owe me money. So there needs to be contracts in place so there's proof that money is owed by the estate to the business. There's also, so businesses are actually kind of interesting because there's also this whole other component. If the estate actually owns, so the person in the state, say they own 50% of a bunch of operating companies, right? That's also, the estate could have a claim in that company, and it becomes very complex and difficult if there's directors of those underlying companies. The estate owns, say, 50%, so they maybe don't have control over those entities, but they want to know what's going on to them because there's a portion of those dividends that should be coming back to the estate. So there is ways to appoint an administrator, and within that order that appoints the administrator to give it superpower, to give the administrator powers to go in and look at the books and records of the company and figure out whether or not it is insolvent. Maybe the companies are insolvent and they need to be wound up, and so that the estate executor and those beneficiaries can figure out what's the best course of action to get some of those assets back into the estate.
So what I'm hearing you say is the importance to document intention and have things, even if it's within family members, maybe even more important that things are clearly documented in case somebody passes away or becomes incapable.
Yeah, absolutely. And the more documented, the better. Obviously, you can have loan agreements that can be quite complex, that have all of the terms, repayment terms, et cetera, in them. But even anything like a promissory note or a credit or demand note, anything that is in writing that says the intention of what those funds are is better than not having anything.
Are there ways to structure the loans particularly between family members that would maybe make it an easier for a professional to look at and accept that type of documentation?
Yeah, so I think if you have the actual contract in place that says I'm going to lend my adult child X amount of money for this period of time, I do not expect them to pay it back. So having those terms in there, or saying this is a gift, and you might not normally think of that, right? You might just give your child a gift. right? And not think of formalizing that gift. But if you don't, you run the risk of the trustee or administrator needing to claw that back. So even if it's, so the way to structure it definitely is by way of some sort of loan document with the intention. The intention is the big part that you want to make sure that's in there.
So we're using terms, I guess we're throwing terms around that our listeners might not know. So we're using words like secured debt, unsecured debt, joint debt, guaranteed debt. Can you help us understand what those different terms mean?
Yeah, sure. So secured debt is when usually it's going to be a loan from a bank or a big creditor where they've lent you money and they've secured against your assets. So they've used your assets of the person or the company as collateral, and they've registered that security under the relevant act, so the PPSA, or they've got security over
the PPSA, the Personal Property Security.
Yes, Personal Property Securities Act. Yeah. Thank you. And so that's secured. And once you've secured and you've registered it properly, your security, that lender then gets priority. So that's where I was saying, apart from funeral costs and admin costs, those secured creditors get paid back first, even over, say, life insurance proceeds that have beneficiaries. Like the secured creditors really do take a priority. Unsecured creditors, we talked about, those are the ones that are kind of don't have any security. And if there's some money left over, then they might get some. In an insolvent estate, beneficiaries don't get anything because there's no assets left after you paid the creditors. Joint debt is just when two people take out, are jointly liable for the debts. And co-signing is when you've co-signed with someone else on a debt. Guaranteeing is you've guaranteed someone else's debt. So in all of those circumstances, and we previously mentioned, is the deceased obviously has the responsibility for their own debt, but let's just take guaranteed. If you've guaranteed that debt, the estate's insolvent and there's not enough money to pay for the deceased person to pay back their loan, then that guarantor is on the hook for the whole thing. So a lot of parents and adult children co-sign loans. There's joint credit cards. Yeah.
And so if there's not enough in the estate, then the surviving borrower, are they often on the hook?
Yes, they are on the hook. And it's especially in insolvent estates. But yeah, they're on the hook for all of those charges. And sometimes it's as easy as sure, I'll sign that. But, you want to be careful and make sure that you know what you're signing and your responsibilities and liabilities should somebody be deceased.
So what I've seen in practice from doing estate administration for years is some of the larger financial institutions I've noticed have not, I think for PR purposes, or maybe they feel like their expenses will exceed the return. But I have seen some people, particularly with some of the, so many people have died in midlife with fentanyl and things like that, like extremely tragic. And often the parents have been guarantors of like a credit card or a $30,000 line of credit. And it's been interesting. The larger financial institutions I've noticed have not necessarily realized on that with the surviving parent. And, I think they must do some sort of analysis and make a business decision that they don't want to do that. But obviously there's no guarantee because legally that surviving parent would be responsible.
Yeah, we've actually, always advising people, you want to say, look, you are responsible. They can come after you. Same thing with like a director's liability for CRA debt. Are they going to go after you? I don't know, but they certainly can. So that's always the advice. But now more than ever, because of all of the social media and how easy it is for, one wrong message to have a huge impact on companies. We have noticed as well that they're very careful on who they decide to go after, for sure.
Right. And so we've talked a lot about insolvency and bankruptcy, but can you help us understand how those are different or the same?
Yep. So insolvency and bankruptcy are very different. So insolvency, you can be insolvent and that's totally fine. lots of people are probably insolvent. You've just got your, you've heavily leveraged and you're working out your plan to go forward, and you just don't have the assets there because you're working on it. Or you've gone to school and you've taken out a big loan, right? There's lots of people that are insolvent or companies that are insolvent. But that's much different. Just not being able to pay your debts or your assets being less than your liabilities, much different factually than if you are bankrupt. So bankruptcy can happen under the Bankruptcy Insolvency Act in Canada, either by way of assigning your own self into bankruptcy. So you have to engage a licensed insolvency trustee, and we will help you assign yourself into bankruptcy. And then we come in, take possession of the assets, and we administer the whole process. The other way is if a creditor isn't getting paid, they can petition someone or a company into bankruptcy if they're owed more than $1,000. And then they would go to court, and the court would appoint a trustee to do kind of the same thing. So it's a actual legal process under the Bankruptcy and Insolvency Act. It's a formal process that needs to be carried out and administered, whereas insolvency is just a state of the person's financial affairs.
So what is, I remember as a young lawyer, we used to talk about the CCAA. What is that again, and how does that come into force?
Sure. So the CCAA would be for companies. The CCAA is an act, Companies Creditors Arrangement Act. There is a similar provision under the Bankruptcy and Insolvency Act, but what they're used is to restructure companies. So a company that wants to continue on, that needs some breathing room from its creditors. Maybe they need to disclaim some contracts or leases that are unfavorable in order to move forward. Maybe they need to sell a portion of the business, but they need some breathing room to do it because their creditors are banging down the door. So the CCAA allows for that stay of proceedings against creditors. It allows for the company to stay in possession of its company. Management can stay in place. The court appoints, it's all very court-driven. The court appoints a CCAA monitor. So we would be appointed as a monitor, and we're kind of the eyes and ears of the court and the creditors. We come in and assist the company in its restructuring efforts. So whether that's running a sales process to sell the company, to sell a portion of the company, collecting creditors' claims, provide a plan to the creditors that says, we're going to sell these assets, we're going to get this much money for it, we're going to pay back cents on the dollar to these unsecured creditors, we're going to pay back our secured creditors, we're going to refinance this portion of our debt, and then we're going to carry on. So that's kind of the plan that goes to the creditors. Creditors vote on it, and then it gets implemented. So that's a really useful tool because it's so court-driven, and there aren't many actual the law, the CCAA law, is short and it's very flexible. You can basically go back to the court and ask for relief for whatever you want within reason. And it makes it a lot easier to restructure the business. You have to have at least $5 million in debt to use the CCAA. If you have less than $5 million in debt, you can use this similar, it's called an NOI, or a Division I proposal under the Bankruptcy and Insolvency Act. But that one is very driven by the rules and less flexibility.
So Greg and I, as we were driving here and stuck on Georgia traffic, we were looking at the Bay building and wondering what's going on with the Bay. What's happening with the Bay right now?
The Bay is in CCAA. Mm-hmm. Yeah, so they were looking to try and figure out whether or not they could sell a portion of it, sell the brand. Did the brand still have value? I think there was hope originally that there would be somebody that would come in and buy that. I think they're still looking at options. They have since decided to liquidate, so they're liquidating their stores. And then they have obviously approximately 10,000 employees, I think. So I think there's a lot of work that's going to have to happen on that claim side of things. So employees obviously are also creditors. They're owed money. So there's going to be a whole exercise where someone's going to have to figure out who all the creditors as well as the employees are, who's owed what money. That's going to be a huge exercise. And then the Bay will either sell its brand, and it will probably just continue to liquidate the rest of the actual inventory and call it a day. So it will be a liquidating CCAA. Usually the company goes on, someone buys it and it goes on. But in this case, I think the intention is to be a liquidating proposal, although unless you're the actual monitor, you don't really know what's going on or the company. So,
Yeah, I think the difference would be in the case like in America, especially airlines go bankrupt all the time because of cash flow issues.
yeah.
You're not allowed to fly for 5 days. They go
It's huge
bankrupt, right?
impact. Yeah.
Or COVID, and they all just file, and all their creditors need to keep them in business
Yep.
because who else are you going to sell airline fuel to?
Exactly. So there's a huge incentive for creditors or other investors to make sure that it's funded,
Right.
right? So another big benefit of a CCAA is someone can come in and fund, and the court can order that funding has priority above secured creditors.
Mm-hmm.
So they get paid back first out of any sales, and that's a benefit of the CCAA. So it's called interim funding or DIP, debtor in possession funding, which is an airline or the Bay or anybody that puts money into an insolvent entity in a CCAA would get that charge.
So can you explain right of survivorship in joint accounts and how it interacts with estate debts?
Yeah. So a right of survivorship is when two people jointly own a property. So it's jointly own a property. So if one person dies, then the other person that property automatically vests with the surviving person. Right. So I think that's the right of survivorship. Those assets obviously don't form part of the deceased estate. And then I think it really matters too whether it's an adult child or whether it's a minor child. I think if it's a minor child, so say it's a joint bank account, I think if it's a minor child, it's assumed that is a gift, and that's fine. I think if it's adult child, and I think there's case precedent on this, if it's an adult child, then unless there's some sort of proof that was a gift, then it's actually part of the estate.
So that's exactly right. There's a case called Pacor that was a Supreme Court of Canada case because there were so many disputes and conflicts about that. So that's exactly what it is. If it's a spouse, it's deemed to be an asset of the spouse. But if it's an adult child, they're deemed to hold it in trust for the estate, unless there's documentation that proves otherwise.
Right, and that Pacor was where the father put the assets in the daughter's name, and then it was determined that was an asset of the estate. Yeah.
So just like you mentioned, the importance of documenting everything. So in the estates that we administer, and so many disputes come out of joint accounts where they haven't documented their intention.
Yeah.
And there's not just creditor issues, there's tax issues and allocating of assets. But I was going to ask you a question. So you go in as a monitor or a receiver. What's that like when you knock on the door of a distressed company? Is that a friendly feeling, or what does that feel like when you have to go in and be the eyes and ears of the court?
Yeah, so it really depends upon the situation. It depends if the management in place is happy to have us there as advising them and they really want to get through this. It's different if it's a receivership. So monitor, you're probably working with the company just before anyway to help them through and understand their options. That's better. If you are a receiver, so you're coming in to take over the company on behalf of the lender. If the owner doesn't want that to happen, say the owner has been telling the bank, I'm getting refinanced, please leave my company with me. Don't worry, you'll get your money, but it will, they've forbeared, it's been a year. The bank decides to put in a receiver, that's a less form of a welcome. So at that time, you have to come in and you're taking possession. So what we have to do is put a notice on the door that says the company's in receivership. We have a court order that says that we now own your company. And we go in and you have to get all of the employees together, let them know you're going to assess whether the company should continue or not. And that brings a lot of uncertainty to them. So and a lot of the time they hadn't been paid for the last 2 weeks too. So they're rightfully very concerned. That's always kind of the worst part of it is around the employees. And then management, they usually don't want you in there. If they could be helpful if they care about making sure the employees have information, but they usually just run out the back door. Then you got to change locks, keys, get computer passwords.
I have a personal experience with this.
Oh,
Going to a friend's birthday in May, maybe 2 decades ago, celebrating at a well-known Mexican restaurant food chain. The receiver showed up and said, everybody out. So it wasn't the whole chain, but one owner owned 5 or 6 between Winnipeg, Calgary, and such. We were allowed to finish whatever beverage you had on the table, but that was it.
That
out
sounds
you went.
about right.
Wow, that's
Happy
dramatic.
birthday. It was dramatic. Traumatizing.
It is dramatic, and I guess maybe we're used to doing it, but nonetheless, we do recognize it's dramatic. We just took possession of a place the other day, and there was one employee in there. The director hadn't told them that this was going to happen, and she was like, "Oh, that's my personal laptop. Can I keep this?" That it's like, no, you have to leave absolutely everything and leave. And it's very confusing to them and lots of uncertainty. And if that was her laptop, obviously we'll determine that and give it back to her if it is. But it's a scary process. And even like you weren't even an employee, you're just a customer, and it's awfully intrusive. Mm-hmm.
So many people assume that life insurance automatically pays off debts. What's the reality, and what should people check to ensure financial security for beneficiaries?
So life insurance definitely doesn't automatically pay off the debts. If there has been beneficiaries you have to make sure that there are beneficiaries assigned under that life insurance policy. If there are, great. Those aren't assets of the estate, and the insurance company will just pay out the beneficiary themselves. If the beneficiary is the company, or it's just payable to the company, then the life insurance will come into the estate. And then it pays off, especially in insolvent state, you're paying off all of those secured creditors, et cetera. So the beneficiaries, who generally life insurance, you'd think it was for the beneficiaries or the heirs, it's not actually ever going to get to them.
Right.
So it's very important to make sure you're
right. And even that insurance may be insufficient to pay off the debt.
Oh, yeah, absolutely. Yeah.
So there's a lot of economic uncertainty, and tariffs are going to put huge pressure on businesses, and the cost of living and housing is exceeding what people make. So I think there's a lot of quietly distressed businesses and individuals. Do you have tips for them if they're struggling with debt? What do you think they could do? Could they come speak to someone like you, or?
Absolutely. So your first step should be to talk to someone. Just call us. We've got so if you're an individual, I do corporate insolvency, but we have the biggest practice in the country. MNP has a consumer practice as well. Mm-hmm. So come talk to us, because your most important thing is to understand your options now. It's a short call, and we just explain to you whether you do need our services or you don't need our services, or whether there's something else you can do in the meantime. A lot of the time, informally, you can restructure your debts. So there's also either you can call your own banks and try to refinance or consolidate debts, or there's lots of services that can do that. But I would say that conversation is really key, because the longer you wait until you are really, really insolvent, the more likely it is that you'll go bankrupt. If you talk to us when you think there might be an issue, but there's still some runway, there's so many more options to help you. If you're an individual, or if you're an individual with a small business, there's so many more options that we can walk you through and try to, preferably informally, because going into any process costs money, but informally just to try and help you restructure. But mnpdebt.ca is a great resource for that.
What is the typical timelines for personal bankruptcy versus a commercial bankruptcy? Like a personal one is relatively quick, is it not in general?
Now you're really testing my knowledge, because I don't practice consumer insolvency. But yes, it's faster. So you can be automatically discharged after 9 months as a person, like a consumer insolvent. Mm-hmm. So as long as you haven't been bankrupt before, and you don't have any surplus income, so you're not making a whole bunch of money that should be paid back to your creditors, you can get discharged pretty quickly. And then all of the debts that you have, provided there's some debts, if they were created fraudulently, et cetera, that aren't discharged, but for the most part, your debts will be discharged and you can go on your way. Bankruptcy for a corporation is a much longer process, because a corporation will own assets that you need to run these sales processes in order to realize upon. they might have tons more creditors than an individual would have. So got to pay out those creditors and hold creditors meetings and all of these things. So it just takes a little bit longer to do the corporate one. But in that sense, the creditors are waiting to get paid out, but the director's not involved anymore because we come in as and run the company.
So we hear the word consumer proposal. How is that different than a bankruptcy?
Yeah, so maybe it's not exactly the same, but you can kind of equate it under the Bankruptcy and Insolvency Act to that Division 1 proposal I was talking about, or the CCAA, is just for a consumer. So what it does is the consumer stays in possession of all of their assets, but it gives them some breathing room from creditors so they can figure out, how do I propose a plan to my creditors where, and the plan might say, I'm going to continue to work. I make X amount of money. I'm going to be able to pay back these creditors, these 75 cents on the dollar over a period of 5 years. And this is going to be my payment plan. So it allows you to structure that proposal to your creditors. So the creditors then vote on it, and if they approve it, which hopefully they will, because the alternative is a bankruptcy, and creditors aren't going to get more in a bankruptcy, then they can implement that plan and kind of go on their way. So then you keep your company, you don't have to file for bankruptcy. Less stigma is generally attached to a restructuring rather than a bankruptcy.
So we're hearing a lot in the community about like housing and the affordability crisis, but is it true that a lot of developers are having difficulty with the cost of land, development costs, and borrowing costs? The word is that developers are struggling. Is that true?
Absolutely. They are by far the number one industry in Vancouver that is failing. MNP, we do a lot of work, probably the most work in real estate in the city in restructuring. So developers are definitely struggling. There's a number of reasons why. So the market is softening. So a lot of the time there's pre-sales that have happened. So as those pre-sales need to complete, if the interest rates are too high and people don't have any money to actually get the mortgage out, or their lender won't lend them the money, you can't complete on the remainder of the sales. That means that you're not going to be able to have that money to continue with the build. In addition, costs are rising. So with pre-sales, you've locked yourself into those pre-sale sales amounts, whereas costs have been rising. So you're not getting the profit that you would have otherwise. So developers are finding themselves in a situation where either there's no available people to work in construction because they're working on other projects, or they just don't have the funds the project doesn't economically make sense anymore because the costs have risen too much compared to the sales price of the units. So they're struggling with that. At that point, you kind of have to build it out because your alternative is to sell the unit unfinished, and there's huge discounts that come with that. So we are generally engaged as a financial advisor to either the lender or to the developer to help them walk through, should you continue, should you redesign if you can, depending upon the stage you're in, and see if you can get some more units out of it or some additional funds. And then, should you continue on? Should you cut your losses and sell it now and then go from there? And you can also use the CCAA and receiverships, et cetera, with respect to developers as well. But that could be a whole podcast.
Well, is there any final tips for our listeners?
Yeah. So I think if you're an executor and it's a complex insolvent estate, there are liabilities, and there's a lot more scrutiny if you are insolvent. So I would have a good think about whether you want that role or do you want to appoint an administrator. I would reach out to either an estate lawyer or an insolvency licensed insolvency trustee to just discuss your options, your the potential risks, just so that you're aware. If you do take the role on, I would say make sure make sure you're maximizing those realizations, make sure that you're paying out in accordance with whatever priority you need to. And then I would just document everything, make sure you're really keeping a lot of records of what you've done. Mm-hmm. Yeah.
Great. Well, thank you so much, Holly. This has been amazing, and we really appreciate your expertise.
No problem. Thank you very much.
Thank you.
This podcast is for informational purposes only and should not be considered individual legal, financial, or tax advice. Make sure to consult the advisor of your choice to advise you on your own circumstances. Thank you for joining us for this episode of Your Estate Matters. If you like this podcast, make sure to follow it on your podcast platform of choice.
Whether you are planning your own estate or you're acting as executor for somebody else's, Heritage Trust can help. Partner with Heritage Trust to protect your family, your assets, and your legacy.
If you would like more information about Heritage Trust, please visit our website at heritagetrustcompany.ca.
This podcast is produced by Podfather Creative.